Welcome to the Birth Launch Podcast, an empowering space for expecting and new parents to hear candid conversations with experts and learn how to craft your ideal birth. We will tackle the scary and weird questions that come up along the way and provide answers that are driven by science and evidence-based recommendations. I'm going to show you how to redefine parenthood and choose what's best aligned for you and your goals. With 10 years of experience in family education and a master's degree in human development and family studies, I'm ready to help you navigate pregnancy and explore your birth options to free yourself of fear surrounding childbirth. My goal is to help you have an informed and confident labor experience, plus an empowered and joyous postpartum. Ryan, welcome to the show.
Hey, HeHe, thank you so much for having me. It's so good to be here to talk about your rights at work, especially during what's supposed to be one of the happiest times of your life, bringing a new kid into the world.
Yeah, well, obviously very, very happy, but I think a lot of the things that we're talking about today are the stressors. This is the mental
Hmm.
health that people don't think about. You're like, yay, I'm pregnant. Woohoo, baby. Oh, shit. How am I supposed to leave work? How early do I tell them? When am I supposed to tell them? What legal rights do I have? What if they say I don't get paid? How am I supposed to make this work financially? What do I do about the insurance? There's just so many things mental load wise that people don't think about. So I'm really, really, really excited to talk about this today. This season actually was all requested by our listeners. And so
Ah,
when I saw people talk about your rights at work and understanding your rights to parental leave and feeding your baby and any
mhm.
sort of accommodations that you need in pregnancy, I was like, all right, I know exactly the human that I want to have on. And so it's an honor, truly. I'm very, very excited to have you on. Can you start by telling us a little bit about? I know I said that you were a workers' right lawyer, but what does that actually mean? What do you do every day? What kind of cases are you dealing with and people are you helping support and protect?
Well, thank you for asking. Yes, so I am a workers' rights lawyer, and my firm, Centurion Trial Attorneys, is an employment law practice that specializes in plaintiff's side employment law. That's a fancy way of saying we represent you, the employees, against businesses. Now, what kind of claims do we deal with? A lot of wage theft, wage and hour, people not getting paid properly, their pay stubs are incorrect, they're not getting paid for all hours worked, things like that. We get a lot of that. Good old fashioned discrimination. There's a myth out there that as time is going on, it's less common in the workplace. It's really not. Discrimination is still a very serious problem. Race, national origin, gender, age discrimination is very common. Disability discrimination is perhaps the most common that we see.
Wow.
And then we do see a lot of sexual assault and sexual harassment cases. That probably represents maybe about 15 to 20% of our total claims are sexual assault and sexual harassment in the workplace. And we also assist with things like retaliation, FMLA retaliation. We're going to talk about that today. If you are requesting an accommodation for your pregnancy under the Pregnancy Workers Fairness Act, and they refuse to accommodate you, or if they punish you for asking, those are the kind of cases we'll take on to assist with.
Okay, that I was just taking so many notes. So many things that I think we need to dive into. So, why don't I throw the ball back to you and you give us the starting point? Where should we kind of dive in and then I can gather my thoughts about how I want to ask the questions I have floating around in my brain from what you just
Okay,
said.
perfect. Well, when we look at your rights in the workplace, there's a couple of things I want to make sure just to set the scene so we all have the same expectations today. The United States has a federalist system of government. That means we have the federal government located in Washington, D.C., and they set laws that apply to the entire United States. All 50 states they set laws for. A great example would be the minimum wage. Federal minimum wage is $7.25 an hour, which is pretty low. Hasn't changed since 2009, and I don't think there's any immediate plans to change it. But the states, because we have a federalist system of government, the states can add other laws on top of the federal law. So long as the state law doesn't conflict with or undermine the federal protection, states can add their own rules. Why is this relevant? So we know the federal minimum wage is $7.25 an hour. But then you go to another state like California, where it's $15.50 an hour. The states can add protections to what the federal government establishes. They just can't do less, even if they really want to. And we can talk about that a bit. Now, why is that relevant? We'll talk about things today like FMLA leave or the Pregnant Workers Fairness Act. We'll talk about ADA, and they will apply to certain employers in certain situations. What I want listeners to be mindful of is your state may have additional protections on top of what we talk about today. I'm not going to get into the weeds of how Oregon and California and Illinois are different than the federal standard because they add extra protections. So for today, we're going to focus on the federal standard. Okay. Now, that's an important thing to be mindful of. Federalist system of government, federal government sets the base rule that applies to all 50 states. Your state may have additional protections. Now, when we talk about what specific protections happen when you are pregnant, when you are coming back to work from the pregnancy, when you're nursing, things like that, these protections fall into three big baskets: preparing for childbirth, the actual giving and recovery from childbirth, and then that 1 year period after the child is born. Those are the three basic chapters of workplace protections we look at. Now, there's a few broad categories, broad statutes we're going to look at today, and I hope we can talk about them in some detail. The first is the Civil Rights Act. That's Title VII of the Civil Rights Act. Now, what's funny about that is that was made into law back in the 60s, and it actually didn't include protections on the basis of pregnancy. That didn't come until the Pregnancy Discrimination Act of 1978. I think it was almost 14 years later when pregnancy became protected under Title VII. So pregnancy discrimination protections, sadly, they're fairly new in the United States, but they are protected under federal law. So you are protected from discrimination on the basis of your pregnancy. The United States also is one of the few developed nations, we are a minority, that does not have a federally mandated paid family leave program. So unlike pretty much every other country who we would consider to be a peer economically, we don't have that. Instead, we have the Family Medical Leave Act, FMLA. Okay. Now, FMLA has its limitations. It only applies to employers of 50 or more workers in a 75-mile radius. You must have worked there for 12 months and 1,250 hours, and you only get 12 weeks, and it is unpaid. Now, we can talk about the details of how to manage that, how to request it, how to come back. So the whole point of FMLA isn't that you're going to get time off. Well, let me rephrase that. It's not that you're going to get paid time off. You're just going to have a job waiting for you when you come back. That's kind of the main purpose of FMLA. And then when you return to work, you have the Pump Act. You also have the Pregnant Workers Fairness Act that protects you while you're getting ready for your leave. So anyway, we can talk about all of these, but just to recap, pregnancy discrimination is illegal in all 50 states because it's against federal law to discriminate on the basis of pregnancy. And that comes from the Pregnancy Discrimination Act of 78, which included the Civil Rights Act, Title VII, to include pregnancy. You also have the Pregnant Workers Fairness Act, which gives you the right to reasonable accommodations during your pregnancy. You also have the FMLA leave, which can give you time off. And then you have the Pump Act. So if you have the need to express milk at work, there's protections there.
Okay, so we have both good things. So we have some protection, but it's not enough. And we have no paid protection for people who are having children. Is that kind of it? Like, I can see where the country is like, we're trying, but we haven't tried in a long time. We haven't tried in a long time. Things are getting better, but we're not meeting the standards of our peers. Kinda?
Yeah, it's interesting. So if we zoom out a bit, let's call a spade a spade. The United States is in a dark place.
Yeah, we
We do
suck in
not have
parental
enough
leave.
support
Right.
for working class peoples because the United States generally, if you look at policy in the United States, it's very much a large enterprise and shareholders first, because that's just how the United States
Operate.
policy has been for the past 5 decades. It's been this sort of trickle down economic theory. If we have low regulations and low taxes, in theory, more businesses will come here, they'll make more money, they'll hire more people. Now, that's probably for a separate podcast. I think it's been proven time and again that just because a company pays less taxes and has less regulations doesn't mean they go out and hire more people. The two issues are not correlated. But be that as it may, yes, the United States is pretty dismal family leave and workplace protections when you're pregnant. But we're not here to be negative. We're here to give people all the information of what rights they do have. So I do want to make sure everyone knows, I know that these are not sufficient protections. I'm not trying to sell them like they're the best thing in the world, but it's what we have to work with. And positivity is going to get us a lot farther than me screaming about how inadequate it is. Let's work with what we got.
Yeah, I think that's
That
where I was
said,
going is that,
yeah.
we don't have a lot, but the things that we do have do exist. And so, how do we
Mhm.
capitalize on them to make sure that you are able to be as protected as you can and at least be informed of what your rights are, right?
Yeah. Yeah. Well, the best way to do it is to at least know what it is, listening to a podcast like this, following a channel like mine, and staying up to date. Because one thing that I think gives us reason to be hopeful for the future is under this current administration, for those listening in the future, we're in 2024. It's the last, maybe the last year of the first term of the Biden administration. We don't know what's going to happen next, but we have two pretty big new rules that came into effect under this administration: the Pregnant Workers Fairness Act and the Pump Act. Those were in 2023 and 2022, respectively. So the reason that gives me hope is we finally, after decades, have some momentum in the right direction. There appears to be momentum towards catching up with other nations in terms of how we treat working families, working pregnant people, things like that.
Yeah. All right. Okay. Slow momentum is momentum. So we'll take it. All right. So maybe
Mhm.
our next step should be to break down what do our rights look like? What does the Title VII Civil Rights Act kind of cover? What should we know about FMLA? There's a lot of confusion about when to tell your employer. Should you
Mm.
disclose it? How do you disclose it? How do you know if you're being retaliated against? What does this look like in terms of our rights versus what you're seeing in the workplace?
Let's do this then. I have a proposal, HeHe. Let's start
Yeah.
with the discrimination protections.
Okay.
Just we'll start with discrimination and harassment because that runs through the entire pregnancy, adoption, foster care, surrogacy, whatever it is. Well, maybe we'll call
Perfect.
it a family growing process.
Yeah.
Yeah,
I love
fun
it.
fact, I've two relatives actually that are doing surrogacy because they're not able to conceive on their own, and they are protected under many of these
Nice.
statutes. So some
Yeah.
people, there's a myth out there like, oh, same-sex couples who are adopting, they're not protected. That's actually
Oh,
not true. If you're a same-sex couple and you're adopting, FMLA still applies to you. So let's talk first about discrimination. So, yes, you are protected from being discriminated against on the basis of your pregnancy. You can't be discriminated against for that. Now, in my office, I unfortunately see a lot of pregnancy discrimination. In fact, it's been estimated by the EEOC. This is relatively old data, but they estimate 1 in 5 pregnant workers will experience some form of discrimination in their career. Candidly, HeHe, I think that's underreported because you have to think of the sample size they deal with. It's been my experience that a minority of pregnant workers experience zero discrimination. Now, how much of that discrimination is legally actionable, we'll talk in a minute, but it's very rare that you have a pregnancy that doesn't get some kind of pushback at work. Now, what does the discrimination protect you from? You can't have an adverse employment action motivated by the pregnancy. You can't be denied opportunities, assignments, promotions, raises that you're otherwise qualified for. You can't be denied employment that you are qualified for just because they would have to accommodate your pregnancy at some point. You also can't be fired just because you are pregnant. You can't be demoted. You can't have your workplace taken to an undesirable location. They can't send you clear across the county in the unlit old office that no one wants to be in that's full of asbestos. They can't do that to you. Now, the problem we come across in these cases is this: if an employer wants to fire you because you are pregnant, spoiler, they're never going to come to you and say, hey, we don't deal with pregnancy at this office. We don't want pregnant people at the job site. So you're fired because you are pregnant. That is never going to happen. That doesn't happen. Instead, what they'll do is they'll do a bunch of bogus write-ups. They might write you up for poor performance. Maybe they were lax with attendance in the past, but now they're dinging you on attendance. They're really watching your time card, or they're just making up issues that are never there. I've actually had cases where the manager made up customer complaints, and he said that they were anonymous complaints. It was pretty rough. Funny side quest about that. We wanted to depose those customers who had made such complaints, and it was very funny how quickly they suddenly wanted to talk settlement. It's because those customers didn't exist. So why is that relevant? Most states, except for Montana, are at will, meaning the default rule in 49 states except Montana is you can be fired for any legal reason or no reason. So a lot of employers, when they see you're pregnant, they'll go, oh, we'll fire her for performance, or we're going to fire her for no reason. And that way it's not discrimination. And that's just not how it works. If you are pregnant and you can show that your pregnancy was the substantial motivating factor for you being terminated, you can bring a discrimination claim. Now, what are some clues that we look at to enforce this provision? You know, it's so funny how the timeline will work out. We'll have an employee who's a star employee, maybe got a raise recently, no complaints, everything's fine. Then suddenly she's pregnant and now she's getting written up every 2 weeks. Now suddenly the boss doesn't want to call one-on-ones with her. You can piece this together. So even though I may not get an admission from an employer who says, oh, we fired her because she's pregnant, we can piece things together. Before pregnancy, no problems with this person. Or maybe there were a couple, but they were really egregious infractions or legitimate issues. But then after the pregnancy, suddenly my client can't breathe without you saying there's something wrong with it. It's very suspicious. So that's how the discrimination laws shake out. And that'll protect you throughout your pregnancy. It'll protect you a little bit postpartum, but the farther away we get from the childbirth, the more it's going to look less like pregnancy discrimination, perhaps gender discrimination. So anyway, that, as a lawyer, I have to be mindful that once we start talking, it's hard to get us to shut up. That's the discrimination. That's
No,
our
that was really
baseline that we're
helpful.
working with. Yeah.
Yeah, that was super, super helpful. So you're basically looking for kind of a flip of a switch in behavior from, I assume this doesn't have to be your direct employer too. It could be a manager. Would that, and maybe that is something that you then kind of go to someone higher up and say, hey, I'm experiencing this. Is,
Mhm.
what does that look like? It may not necessarily result in termination or being fired, but what does it look like within the, kind of the walls of just harassment?
Yeah, that is a fantastic question. So let's address it in two parts. The first is, what if it's not really the company? It's not a company policy. It's not the
Totally.
CEOs or the owners. It's my manager. Well, here's how the discrimination works. If it is a manager with hiring and firing power, the liability to the company is automatic in most situations. And I don't want to say all, just most. It will be rare that it's not, because they're acting on behalf of the company. So
Sure.
honestly, most of the time I've seen it where it's an institutional problem, but it's very rare that it's like, oh, this is just our policy, we don't do this. It's typically a HR rep who maybe has a personal beef with that employee and they let personal issues get in the way of their professional obligation. A manager who is just lazy or selfish or bigoted, or again, a manager who's letting their personal biases against one person dictate how they act. And unfortunately, we do get, man, I'm going to piss off a lot of people right now. Republicans have jobs, and Republicans let that ideology affect their judgment sometimes. And I know that's going to make some people very upset, but the truth is, we deal with a lot of businesses where they'll say, why should I have to deal with your decision to get pregnant? Why should the government tell me that I have to act different because you decided to get pregnant? Very much this rugged individualism mindset permeates into some workplaces. So anyway, we went ahead and got a bunch of angry comments, I'm sure, but I'm just telling you what I've experienced. That's what we see. So anyway, the managers might act and do this. So you can have a claim even if the manager went rogue, so long as it's within the scope of their duties that they're doing this. They had hiring and firing power. What about harassment? So harassment is going to fall short of straight up termination. So let's say you're pregnant and you tell your employer, hey, great news, I'm expecting, due date is, June 3rd. It's, and I'd like to know more about my rights and my leave options. Some employers, not all, might have a little meeting after that and say, what are we going to do about HeHe? She says she's pregnant. We don't want to deal with her leave coverage. What do we do? And it's like, just be hostile to her, make her uncomfortable, and maybe the problem will resolve itself. It's very sad, but these things do happen.
Hmm.
So they might bully you, target you for just rough behavior, icing you out of meetings, giving you impossible workloads. One thing that I see a lot of in my cases is unreasonable work requirements and expectations. not expected of similarly situated employees. So I did have one particular case where we had a pregnant worker, and basically, how do I put this? Basically, how it was she was an account manager, and it was common for them to have maybe 40 accounts on their desk. Well, once she announced that she was pregnant, they tried to chalk it up like a promotion. They were a little sneaky with this case. They said, "Oh, congrats, you're getting promoted. You're getting promoted. We're going to double your caseload and you'll make more money." So technically it was a raise and technically it was a promotion, but what they did is they doubled her workload. And what we were able to show was they had done that because they wanted to push her out. They knew it was an impossible workload and they just wanted her to fail. And in that case, we had to show, look, this was a targeted campaign. It wasn't a promotion. It wasn't a raise. This was an impossible workload for anyone. And the real purpose was to push her out. So that's one thing we might look at. We would call that retaliation, although it's an unusual circumstance where it's characterized as a good thing. But as for harassment itself, we're looking at severe or pervasive conduct targeted at you because you are pregnant. It can't be personal. It can't be, I just don't like HeHe because I don't like her face. That's not good enough. It has to be he was great. She's pregnant. That's really inconvenient for me. I don't like it. So I'm going to target her for outrageous conduct. I'm going to say horrible, mean, nasty things to her. I'm going to just pepper her with stuff every day. Those kind of things can be harassment. So in most discrimination cases, there's usually a harassment component in there because for me, it's very rare I see a discrimination case where they just let you go without anything. Usually there's a little bit of pretext or some bullying or harassment that happens before it.
Yeah, they're like a peanut butter and jelly. You can't really have one without the other. I mean, you
Yeah, they're
can,
not the
but
same, but they go
yeah.
hand in hand. Yeah.
Yeah, for sure. Okay, do you ever get employees that you talk to and they're like, "Yeah, no, these conversations definitely happen. We definitely met in a boardroom and talked about, you know, her pregnancy and we kind of made a plan on how to get her out."
Yeah, it's I've had a few go that way. It's really sad what I see. I've had employers take my pregnant client out to lunch and then at the lunch basically say like, "Hey, you need to get your priorities right." As she's sitting there with a baby in her belly. Get your priorities right. You know, they'll say, "Hey, if you value your career, you're going to have to not," what did he say? He said like not get distracted or something, like implying that her child was a distraction, as if our families are not
Hmm.
the number one priority in this
Yeah,
world.
literally.
Our jobs are not. This is something about American culture I think needs to get fixed. It's perfectly fine to have pride in the work you do. In fact, I think it's wonderful. We might
Totally.
call that your dharma or your ikigai if you follow those schools of thoughts where you get fulfillment and happiness out of your
Totally.
trade. That's a beautiful thing. But don't forget that all jobs exist to support your life outside of work. It is a tool to give you the nursery, the home, the after school programs, the time off to watch your child grow. Because no one goes to their deathbed saying, "Oh man, I wish I pushed a few extra units in Q3 of 2025." God, they don't say that. They say, "I didn't make any recitals and now I never will." That's, I mean, that's the truth of this. So when a boss pulls a client aside and says, "You need to not get distracted, you need to realign your priorities, you need to decide if you're a team player." If a boss says the phrase team player to you, that's a major red flag. Team player basically means let me abuse your rights and don't tell anyone. So yeah, those conversations do happen. There's a myth. I encounter this a lot. People who are not in my line of work genuinely think that it would never happen because it is outrageous. It's outrageous. And perhaps in their workplace, it wouldn't happen. Good for you. That's one workplace. But I'm telling you, I do thousands of these cases every year at my office. It's very common and it can happen to anyone. Even if you have a boss that really likes you and you think, "My boss would never discriminate on pregnancy. We're so close. She's a woman. She's a mother." You don't know what kind of pressure is coming from above that manager. So I'm not telling you to be paranoid or afraid. I'm telling you not to get complacent. Just
Yeah.
understand your rights and make sure you're establishing a paper trail that enforces those rights. Now, you asked a question at the beginning of the pod. Do we disclose that we're pregnant? My advice is yes, do disclose because you cannot win a claim of discrimination if the employer had no idea you were pregnant. or more accurately, they can make a convincing argument that they didn't know, even if they really did. So the standard is you're protected, but the employer must know or reasonably should know that you're pregnant. So to do that, we have to put them on notice. You are not able to be fired for being pregnant and say, surprise, I was pregnant, but you didn't know. You have to put them on notice. So I say, put them on notice, do it in writing, save a copy of that for yourself. And the best way is to keep it short and sweet. When you find out a due date and it's looking good, you say, hey, boss, great news. Happy to announce I'm pregnant. My due date is X. When can we have a meeting to discuss accommodations and leave options? That's all you got to say. You don't need any legal mumbo jumbo in there. That's all you got to say, and keep a copy, because now from that date forward, the employer is on notice that you are pregnant. And now it's much easier to have those discrimination rules apply. And candidly, if the HR department is doing their job, that should put them on notice like, hey, we need to be respectful. We need to be cooperative with this employee. One more thing I want to touch on in regards to disclosure. This is a very unpopular piece of advice that I have, but I have reasons for this. If you are applying for jobs and you're inspecting and you're not visibly showing, I'd announce after you get the job, because the harsh truth that no one wants to talk about is that if you tell them you're pregnant in the job interview, you're probably not getting a call back. You might, but it's not likely. Wait till you get the job and then tell them after. Now, some people get really upset and say, oh my God, that's so sneaky. That's so horrible. You're a liar. Why would you do this? It's like, you got the job. So you're clearly a qualified employee. And under our laws, you have the right to be considered for employment that you're qualified for, and you shouldn't be denied that employment just because you're pregnant. So what we've done is we've given them the information, but we gave it to them after the hiring decision. So we've proved that you're a qualified candidate, and now we'll just accommodate you later. And frankly, I don't lose a lot of sleep over these big employers. I mean, I've seen them do horrible things to pregnant employees. The least we can do is just say, hey, I'm not going to give you a reason to discriminate against me. But once I get in the door, I'm going to let you know about my protected status, and I'll keep doing this job. Because as long as you're qualified, in my opinion, it's not a lie.
Totally. Yeah, I think it all goes back to pregnancy doesn't mean you can't work, and you're working in order to provide for your family. So do that for as long
Mhm.
as you can. And when you have your baby, your job is held for you and you can come back to it.
Yeah.
Okay, so
Yeah, one thing I want to point out is if you're pregnant and you get the job and you disclose the pregnancy after, I think that is probably the most strategic way. Again, every case is unique. Talk to an employment lawyer you trust about your specific situation. These are all just general tips for discussion and education early only. It's not legal advice for any specific circumstances. But with that said, if you get a job and you're pregnant and you disclose after, you're probably not going to qualify for FMLA, not because you did anything wrong, but because you wouldn't have worked the 12 months and 1,250 hours to get there. So your discussion, you can talk about leave options, see if they have anything company sponsored or state that's higher than the federal standard. But really, we're going to be talking about accommodations. That's really what the conversation's probably going to be at that point.
Okay, so well, wait, I don't want to go into accommodations yet because I still have one last
Okay.
question. What are employers allowed to ask about your pregnancy? I think a lot of people believe that you can't say like, "Are you pregnant?" Is that true? If you do get asked that, is there any recourse? Should there be recourse? Are we turning them into people? What do we do with that, and what are we looking for in that situation?
Yeah, I hear you. So there is a misconception about how privacy rights work. So people know HIPAA, that's the Health Insurance Portability and Accountability Act. Okay. And people think, oh, you can't ask me if I'm pregnant because that's a medical condition and it's protected under HIPAA. It's actually not true. So what HIPAA protects you from is unauthorized disclosure of your medical information to someone else. So an employer can come to you and say, HeHe, are you pregnant? HeHe, how is your pregnancy going? Are you healthy? Is the baby healthy? They're allowed to ask and you're allowed to answer. There's nothing illegal about them asking. What would be a problem is if they went behind your back and went to your health provider and said, hey, what's going on with HeHe's pregnancy? And they go, oh man, she has hypertension. She's at risk for some kind of diabetes. And they start spilling the beans. Now we have a HIPAA violation because it was an unauthorized disclosure of your information. So to be very clear, they can ask. Now, how they ask, how often they ask, what they do with that information, it may bleed into a discrimination or some other kind of protected issue, but the question itself is typically not illegal.
Yeah. Okay, great. Great. That really clears everything up. Okay, cool. Now let's go into accommodations. When we're talking about accommodations in pregnancy from your employer, what kind of things should people be thinking about and asking? What's reasonable? What's kind of the bare minimum?
Okay, so let's talk about a couple of things. And we're actually going to talk about the Americans with Disabilities Act first, because before the Pregnant Workers Fairness Act in 2022 or 2023, it was 2022, 2023. Before the Pregnant Workers Fairness Act, there actually was no federal protection for pregnancy by itself. You had the right to be free of discrimination, but there was no requirement that an employer accommodate you for your pregnancy, not unless you had what was deemed a medically difficult pregnancy. So if you had some kind of complication on top of being pregnant, it was a high-risk pregnancy, something like that, then you would get covered under the Americans with Disabilities Act. That applied to employers of at least 15 workers, and you would basically say, hey, I have a difficult pregnancy, I need accommodation. And then the next step would be interactive process, where maybe they talk to you, your healthcare provider can be involved to some extent. You figure out, what do you need? Do you need longer breaks? Do you need parking closer to the office? Do you need more frequent bathroom breaks? Do you need a stool to sit on? Do you need to be excluded from extra strenuous activities? Do we need to protect you from certain chemicals? Like, there's different conversations we can have. Now, that was the old rule. It didn't go away. It's still there. You still have protections under ADA if you have a medically challenging pregnancy in some way. But what the PWFA, the Pregnant Workers Fairness Act, did, and this was 2023, they basically said, no, pregnancy by itself is a health condition that materially affects your ability to work. So now you can get accommodations if your employer has 15 or more employees and you're pregnant. And the reasonable accommodations look the same. It's really very, very similar to ADA. 15 or more workers. We're looking at reasonable accommodations, longer break time, modified schedule. Working from home is a very good one, especially in the post-COVID world where we can have outbreaks and things like that. Working from home is a very easy way to accommodate pregnant employees. So that's the PWFA. There's one
Yeah.
very important caveat we have to touch on. So under ADA and the PWFA, you can get reasonable accommodation for your pregnancy, whether it's a medically challenging pregnancy or not. But there is a huge caveat. If the employer can demonstrate an undue hardship, they do not have to accommodate you. Undue hardship is going to take a couple of shapes and forms. The most serious one would be you literally cannot do your job. If you, just off the top of my head, I don't know if this is true or not, but I'm guessing if you're like a deep sea welder, probably can't do that pregnant. I don't know. I guess technically you're a submarine if you're a pregnant person and you go diving, but I don't think I don't know if that would be something you can do. So that would say, look, you literally cannot do the job we hired you to do. It's not safe for you to be pregnant and go down 1,000 feet and weld dangerous things. Like, you can't do that. The other would be, hey, we can accommodate you, but it's so complicated. It requires, in-depth expertise from experts and trained people we don't have. It would take a lot of money. We need advanced technology that we can't afford. Then they can say it's an undue hardship and not accommodate you. But the cautionary tale I want to put out there, I see this a lot, HeHe. I see this a lot. Just because HR or your manager says it's an undue hardship does not make it so. They need to demonstrate the undue hardship. Great example. I had a client, this was years ago. She worked in a fast food restaurant just as a cashier, and she asked for pregnancy accommodations. Now, this was before the PWFA, but she had hypertension and some related conditions. So she had a medically difficult pregnancy. So we were looking at aid to get her accommodated. And the restaurant just said, nope, undue hardship, can't do it. And they let her go. All she needed was a stool and slightly longer break times. That's all she would have needed. So we were able to show that not only would this be a reasonable accommodation she was entitled to, but your claim of an undue hardship is bogus. We ended up getting her a pretty good settlement, but we had to get an expert and we had to work through that. But the long story short, undue hardship gets them out of it, but it has to be real. And if you challenge them, they're going to have to be able to show it's an undue hardship. Can't just say it's a hardship.
It also just makes me think, like, what kind of shitty people are running these businesses if you won't get a pregnant lady a stool and 10 extra minutes to make it to and from her car. Like, come on.
It's surprising how much malice I see in the workplace. A lot of times
Terrible.
it's mere ignorance. They didn't know the law. They didn't know they were supposed to, but it also raises the question like whether it was legally required or not. Is there any part of like at the end of the day, ignore the computers and the clothing. At the end of the day, we're human animals and we evolved over millennia because we're social animals who took care of each other. So how is it that nothing in your mind, your soul, nothing in your DNA is telling you like, oh, a member of my team is pregnant, I should look out for this person? So when someone says, oh, I didn't know it was the law, I'm like, you didn't know it was
Well,
the
why did
law,
you
but
need a
no part of
law
you,
to tell you to give
yeah,
her a stool? Like, what's
like
wrong
no
with
part
you?
of you told you that this was the right thing to do.
Oh my gosh, it really makes you question society, doesn't it? That's one thing that, every job has pros and cons, but I will say being around pregnant people for so long and watching the things that they deal with and watching how society's kind of evolved in both good and bad ways, it has just made me question society so many times and I'm like, "Guys, come on, we got to get it together, y'all."
Yeah, well, I hear you. And again, there's room for hope. You
Totally.
know, these incidents do happen and they happen frequently. It's why my office
Sad.
exists and why there's many lawyers like me out there fighting this stuff. But do keep in mind that, you know, it takes a lot to get these laws passed. They were passed because the overwhelming majority of people agree that protecting new mothers, growing families is a good thing. And the majority of us know right and wrong when we see it. And if a case like this goes to a jury, unless you're in a very, very conservative jurisdiction, most of the time juries are going to do the right thing. So more people see this as outrageous and see what right and wrong is than don't.
Good. That's
Mhm.
good. That does give us hope. Okay, so can we shift or have we wrapped up the pregnancy stuff or is there anything else that we should know about being pregnant in the workforce? We haven't really talked about transitioning out. Is there anything that we should know about transitioning out for
Yeah,
our
let's talk about that. I mean,
our
honestly,
person?
this could be a multi-episode series because
Yeah.
as scant as protections are in the United States, there are protections, they're diverse, and we have to remember knowing your rights is only half of it. Actually
Mhm.
implementing and taking advantage of your rights is the other half of the battle. We talked about that earlier today with when do we disclose, how do we disclose? The next thing you said, what was it, phasing out?
Yeah, like how do we
Yeah.
leave for our parental leave? Is there anything that we need to know that either protects us or that we should be abiding by that's, will kind of
Yeah. So
get
here's
us
what you're
there?
going to need to do. Definitely consider asking for accommodations under the Pregnant Workers Fairness Act because that's going to do a couple of things for you. You're already protected against discrimination, but it really helps if you put in for the reasonable accommodation because now you're protected under the PWFA and you have this sort of buffer to protect you from unfair poor performance reviews. Even if you think, oh, I'll just stick, I could just be on my feet all day. Yeah, my ankles are swelling, but I'm just going to suck it up. I don't want anything special. Or, oh, I don't need water by my station. I'll just suck it up. I don't want to be special. Don't do that because some employers, not all, but enough that you should protect yourself, are going to look for any little reason to ding your performance.
Hmm.
And if you have an accommodation in place that says you get a longer break, you get to park closer to the building, you get to sit down, you get to not be part of heavy lifting, now they can't say, oh, your break was too long, or oh, you had water by your workstation, or oh, you didn't help lift that crate earlier. They can't use that to say you have poor performance as a pretext for firing you because you were smart. You put in the accommodation earlier. You see how this protects you. We're throwing up little walls around your pregnancy to protect it. And it sucks that we're in a place where we need to do that, but no
We
sense
are.
arguing about, you know, the state of the world. We're just going to deal with it as we take it. So you're protected from discrimination, notify them of the pregnancy. You're protected against pretextual performance reviews, unfair work, unreasonable expectations. Ask for reasonable accommodation. It'll make, and also it'll help protect the health of your baby. If you're drinking water regularly, you're taking breaks, you're getting good nutrition, you're not getting exposed to dangerous chemicals. If you're not willing to do it to protect your career, and there's good reasons for that, I understand it's scary, do it for your child because
Mhm.
those accommodations will help the pregnancy be more successful.
Mhm.
So we've done discrimination. We've done PWFA, getting you
Wait,
accommodations.
I do have one
Oh, go ahead.
question. Sorry.
Yeah,
When you're asking for accommodations, are we asking for specific accommodations, or does a general sentence of "I'm looking for accommodations" kind of cover everything?
fantastic question. So no specific accommodation is required.
Okay.
When we say we want to invoke our rights under the PWFA, the next step, I mean, the employer could just say, oh, yeah, that's totally fine. We'll get you a stool, longer break. Does that work for you? Yeah, that's good for me. That might happen. More likely, what's going to happen is they'll say, well, let's have a meeting and see what you need. They might ask for a doctor's note. Totally reasonable for them to ask for that. Some people think it's illegal. It's not. The doctor does not have to provide any specific diagnosis. And generally, again, nothing I'm saying here is legal advice for any specific situation. It's general information for discussion and education only. Generally, I discourage healthcare providers from providing specific reasonable accommodations. Instead, I say generally, and there are exceptions to this, just give us the restrictions. What things should the pregnant worker not be doing? And then let her and the employer figure out what they want to do from there. So, can't lift more than 20 pounds, shouldn't be exposed to chemical fumes, shouldn't be exposed to certain noise, shouldn't be riding around in bumpy, heavy equipment, needs to be off her feet once every 50 minutes, needs water, things like that. That's what I encourage to be on a note like that. Because if the doctor comes in and says, oh, she can only work the cashier from 8 to 5, and these are the specific break schedules she needs, now you're backing the employer into a corner and they might scream undue hardship. It's a lot more successful if the healthcare provider gives them a basic framework to work with, and the employee can have ideas. You can come in and say, hey, if I worked remotely 3 days out of the week, that would be great for me. That would work just fine. Employee preference is part of the equation, but the employer has to be part of the discussion too. That's what the interactive process is. And by the way, if they fail to engage in an interactive process, that can be a cause of action by itself, depending where you are. So all that to say, yeah, that's what the process is going to look like. It's informal. Getting a note from your doctor helps. No specific diagnosis is required. No specific accommodation is required. Although the Department of Labor has a very helpful fact sheet with sample accommodations that you can look at and consider if they might work for you.
Cool. We'll link that in the show notes for everybody. Okay.
Mhm.
Now I think we're ready to go to postpartum after baby is here. What do our
Mhm.
rights look like there? We had mentioned we're the only country that doesn't, or not the only, but one of the only country that doesn't have federal paid leave. How does that impact you, kind of depending on where you live in the country?
Well, it's really tough for a lot of reasons, because one of the things that parents of growing families and pregnant workers have to worry about is how the hell they're going to pay their bills when they're out. Not only do they have to worry about how they pay their bills, but again, we are a country with no healthcare for people. Most people's healthcare is tied to their jobs. Now, we won't get too deep into this. I think it's better preserved for another episode because it gets a little wonky. Cobra Care can help with this. Um, Cobra can help you maintain some of your benefits. Now, you may have to continue contributing to premiums even if you're away from work. So it's not free and it's not a great solution, but it's something. Now, if we talk about FMLA leave, there's a couple of rules with that. We already mentioned that FMLA is unpaid but job protected leave. So you can't be fired just because you asked for FMLA. They can't say, oh, why don't you just quit and then reapply for your job later? Do not fall for that trap. They can't say, well, you'll just be indefinitely suspended. And then, that can't do that. It has to be, all right, we're going to do FMLA leave. Here's your return date. You can do the 12 weeks all at once, or you can break it up. Intermittent leave is acceptable too. You can do that. But when you return, you must be restored to the same or substantially similar job that you had. It does not have to be the exact same job. And that's fair, because the employer is going to have to figure out, okay, who do I fill in for this role? There are temp agencies and contract companies that specialize in this sort of thing. They'll do 12 and 13-week assignments for a temp. But let's say they filled the role. They just have to put you somewhere substantially similar. The pay doesn't have to be exactly the same. It can be a little less, a little more, but not by much. Substantially similar is really the standard. Now, when you're out, what about your healthcare? In some states like California, we have programs where you can get a percentage of your old wage. It's not going to be your full pay. It's going to be a fraction of what you were making, but it's money coming in. So if you're in California, that's paid family leave, PFL, you get that through the California Employment Development Department. So if you go to ca.edd.gov and you look up PFL, you may qualify for paid family leave. And it operates very similarly to state disability leave, if you've ever done that, where you get a portion of your pay. I don't want to get into the weeds because that's California specific, but all that to say, your state may have paid family leave available to you. Your employer may have paid family leave available to you, but most people, this is going to be an unpaid time off. And what you really need to watch out for is just that you aren't fired for it, punished for it, or demoted for it. Those are the big things you're looking for with FMLA leave. When you request FMLA, like everything we said today, do it in writing. And you don't have to have any legal jargon in there. What I recommend is you just send an email to HR, to your manager, whomever. Keep a copy for yourself. Don't trust it on the company server. I promise you it will disappear very fast. You got to keep a copy for yourself. And you just say, hey, happy to announce I'm pregnant. My due date's coming up. I would like to start my leave on date. When can we talk about leave options? Or when can we talk about FMLA if you want to say that? They might have some paperwork they want you to do. While you're on FMLA, a big trap I see people fall into is make sure you're communicating with the employer about when you're going to come back. And if they have check-ins once in a while, don't get offended and say, oh my gosh, why are they harassing me while I'm out? Like, if they have a check-in, just cooperate. Because one way employers try to get around the restoring you to the same or substantially similar job is they say, oh, you didn't cooperate during the leave process, so we let you go, which is a legal reason to let you go if you're not cooperative during FMLA. So if they check in at 6 weeks and say, hey, how's it going? You still good to come back on this date? Quick email. Yep, still planning on it. How's the family? Family is good. Just cooperate with that process. Don't give them a way out.
Sneaky, sneaky, sneaky.
Very sneaky. And one more thing I want you to look out for is that first 1 to 3 months when you return from FMLA, we will see retaliation for taking FMLA leave. Not so much that it's a guarantee, but enough that you should be aware of it. So when you come back, some employers will have a plan like, hey, HeHe took FMLA. She had her first baby. Lord knows when she's going to have the second. Let's get rid of her so we don't have to deal with this again. So maybe they'll say, well, let's wait 2 months so it doesn't look like it was for FMLA, and let's write her up for all kinds of stuff. So that's an FMLA retaliation case. I see a lot of that. As a general rule, the closer to the FMLA that those adverse employment actions happen, the more it looks like retaliation. The farther away from it, the more I want to look at what happened between you coming back from the leave and the day you got fired or demoted. Were there a bunch of unreasonable performance evaluations? Did they throw a bunch of extra work at you? Were you iced out of meetings you used to be welcome in? Like, did something change?
And what if someone, well, I guess when we say there's no minimum, a company could literally have, well, especially if you don't have the 15 or 50 employees that meet certain requirements, just do people just take out short-term disability if they do not kind of qualify for FMLA and they're not in a state that adds anything on? What does that look like?
So yeah, I'm really glad you asked that because I want to make sure we're very clear about how these programs work. So when we talk about FMLA, there's no paid leave attached to it. If you get paid leave, it'll be in a completely separate program. FMLA provides no payment to you. It does say that if you have a company sponsored health plan or certain benefits, they must continue as they were during the leave. Kind of, it sounds really great, but it can actually become problematic because if you have an employer sponsored health plan where you say contribute 50% of the premium payments, you still have to continue those payments while you're on leave. So you lost your income, but you're still paying for this plan. And if you don't contribute to those premiums, they can dismiss you from the coverage. So, and which is a time when you need your coverage more than anything. So one thing to look out for is if you've got PTO, FMLA is a good time to use it. Some people will get upset. Like, oh, my employer used my PTO. I was on FMLA. I was saving it for a vacation. I'm sorry. I know it's not ideal. I know it's not what other workers and other developed nations get. I know it's not fair, but it keeps the money coming in. It's an option. So now what about getting payment? That's going to be through either your employer, Maybe you have a very large employer with a paid family leave program. Awesome. Apply for it. Or you might be in a state like California that has some paid family leave available. You apply for that separately. That is a separate thing. And like I said, if you're in California, it's ca.edd.gov, look up PFL, paid family leave.
What state has the worst and the best family leave?
That it's funny. They say in matters of taste, there's no debate. It depends on a few issues. Oh, that reminds me of something that I wanted to clarify real quick. Let's just remember the numbers. There's some magic numbers here. 15 or more workers, you're protected under ADA and the Pregnant Workers Fairness Act. Okay. 50 or more workers in a 75-mile radius, you're protected under FMLA. Now, some states, like Oregon is a little like this. California, I'll speak to since that's where my office is. California has the California Family Rights Act. It is very similar to FMLA with one exception. It applies to employers of 5 or more workers in the state with no radius protection. You can have 2 workers in San Diego, 2 in San Francisco, 1 in Sacramento. Boom, you qualify for the 12 weeks of unpaid but job protected leave. And then you can hop on edd.gov and try to apply for PFL.
Nice.
Okay. And you're also protected from discrimination under the Fair Employment and Housing Act. And you have a lot of protection. So it's probably no surprise that it's my opinion that California is probably the best of the 50 states.
Not an unbiased ask, I realize.
Yeah, but I'm a realist. California is the best in the United States, but if you were to take California and put it in Europe, we would be considered a third world country. Our leave programs are grossly insufficient compared to what other developed economies do. So I'm not saying California is the best. I'm saying California is making lemonade in our current framework in the United States. What are the worst? It's going to be a tie and pretty much the entire Deep South.
You were gonna say
and the
Mississippi
reason,
at some point. Well,
yeah, the reason it's not, oh, Ryan's this liberal attorney from California, he just wants to knock the red states. That's not what it is at all. It's any group of states that just has the federal minimum and nothing more. There's a lot of them. I would consider those the last place contenders for family rights.
well, that was
Because
gonna
the
be our next
federal, it's
question.
not great. Yeah.
Yeah, my next question was going to be, are there any states that don't add anything to the bare minimum of the federal requirements? And it
There's a
sounds
lot of
like
them.
there are a number of them. Yeah. Ugh.
Texas, Mississippi, Alabama,
Ugh.
Florida, like the usual suspects. It's not, they won't surprise you.
It doesn't surprise me, but it does hurt my heart. I grew up in Mississippi and I just want so much better for our state. And it really breaks my heart that the people down there who are running those states don't want better for their constituents. We could very easily take care of our women and our children, and we
Mhm.
literally choose to do the opposite. And it
Yeah,
makes
this
me
is
so mad.
opinion. I think there's a variety of reasons for it. The first is, especially since the 60s, 70s, 80s, we became I said this before, so we're large scale enterprise and shareholders first in the United States. All of our policies are really designed to make sure that stock prices keep going up, quarterly earnings keep going up. We need to see growth every quarter, and that's what a lot of policy looks for. And the theory for the longest time was, oh, how do we make the stock market robust? Make sure businesses aren't paying a lot of taxes, make sure they have lots of taxpayer funded programs where they can get money, bailouts, things like that. And also let's reduce regulation. Florida had a big push right in the beginning of the pandemic where they were aggressively marketing to businesses. They're saying, hey, does your state have overly restrictive COVID requirements? Come to Florida. It's good to do business in Florida. We're not going to tell you what to do unless you have woke work policies. Then we will tell you what to do, but that's another thing.
And you're not allowed.
The point is, the reason we have that, it's a business first mentality. Now, some policymakers may legitimately think it's for the workers' benefit. They may in their head think, ooh, I'm going to create jobs and jobs are good. So in a weird way, they're like, you may not like the medicine, but trust me, it's for your own good. What they don't realize is trickle down economics is a farce. I said it before, just because a company makes a lot more money or has a lower tax burden doesn't mean they go out and hire. You go out and hire when demand for your products goes up. If the demand hasn't changed, if demand for your products and services is unchanged and your profits went up, you're just going to do stock buybacks and shareholder dividends, maybe bigger bonuses. What the hell else are you going to do? There's nothing else productive to do with the money. But if we see higher demand for services and workers have more money, they have more disposable income, they have growing families, then we start seeing more demand. And with more demand, we see more jobs being created in a more sustainable way. And what I think has gotten lost in the United States is we got so wrapped up in this crazy culture war that we're seeing. I hate to say that because I know it's a loaded term and there's definitely good reason to believe it's not even real. But just for sake of our discussion today, we call it a culture war where they say, well, we don't want woke. We don't want diversity, equity, inclusion because we think it's fundamentally racist. We don't want special rights for women because that's not equality. We don't want special rights for families because that's not equality. And what they don't realize is it's inherently self-destructive to have a system where people cannot live their lives and they cannot have healthy, growing families. I just look at Japan right now. Japan has a very upside down age distribution in their economy, and it's already starting to create problems. There are cultural festivals that no longer continue because they don't have enough new initiates into those programs. There's companies that are scrambling and trying to hire overseas because they don't have a domestic workforce for these jobs. The consequences of being hostile to pregnant workers are catastrophic. So I'm really glad we're seeing more protection recently. I don't think it's too late for us to course correct,
Okay.
but if you're listening to this and you happen to be very, very conservative or you have very strong beliefs about you don't want special rights for pregnant people because it was their choice to get pregnant, fine, but you need to know that that is a self-destructive ideology. You want these people to be successful because greater economic activity from them will eventually make its way to you.
And don't be a dick to pregnant people. How about that? It's just like a general rule of thumb. Just like
You know, it's
be
so funny
kind to
that
people who are growing our next generation. What?
you're right. And I definitely want to give that statement that it's like obviously morality and just our basic instincts as humans should kick in, but it's been my experience dealing. You got to remember, some people say I'm jaded or I'm a little too harsh on the GOP or whatever, or maybe I'm too biased, I'm too partisan. First of all, side note to the side note, I am biased and I am partisan. I'm a workers' rights advocate. I am not a judge. I am not the president. I am under no obligation to be neutral to anybody. I'm a workers' rights advocate. I am biased in favor of workers. And any group, organization that undercuts those protections, I'm going to have a problem with you, which is why I have a problem with the current GOP platform of 2024, where they're talking about gutting the National Labor Relations Board. They're talking about reducing protections. They want to take the Roe v. Wade situation and take it even further. Like there's just a lot of stuff that I think will hurt
Harm our
working Americans. So I'm going to get pretty hostile about it. But yeah, no, when I deal with these opponents, you'd think morality should come in. A lot of times it doesn't. But what does work with these employers and these policymakers is dollars and cents. It's like, okay, I can't get you to be nice to a pregnant worker out of morality, but maybe I can make you be nice to them if you see that it is economically advantageous to do so. This is one of those gem situations, just rare diamond in the rough situation where the morally right thing is also the profitable thing.
Yeah. Well, it kind of reminds me of the companies that are like very family friendly, like Patagonia has come into
Mhm.
mind, and Google and companies that kind of take care of their parents.
No mention
Um,
of Kite Baby.
mention of
Remember
Kite
that? Yeah.
Baby. Glossing over that. I said my
Mhm.
piece on Instagram about that. I think everyone makes mistakes. It was very sad to see a woman owned, made for by
Mhm.
women brand respond that way.
Mhm.
My business owner heart understood the rationale, but the morality piece of me says, how could you ever do that? Which is
Well, as a
kind
business owner, you just set a very clear message to your staff. Do not be loyal to me.
of,
Do
mm-hmm,
not work hard for me. Don't
mm-hmm.
plan to be with me in the long term because the minute you're pregnant, I'm throwing you under the bus. Again, the moral thing to do is profitable. My office, and granted, I'm a smaller operation. I only have 10 employees, but at my operation, I'm very, very proactive about boundaries, family first, paid leave, or at least, if someone's out of paid leave, like send them something and keep tabs on them. And it's been my experience that inspires the best, most creative, most loyal work product.
Yeah. Well, when your employees feel taken care of, they're going to have their cup filled enough that they can love on your business and they can love on your
Mhm.
customers. And I
Oh
think
yeah.
that, it speaks volume that that was done by a company that serves pregnant women.
Uh,
It's
yeah.
unfortunate. It's really unfortunate.
Well, it raises another issue, HeHe, and that's what I tried to say a few times in this podcast is just because your manager is a mother, just because your boss seems kind and supportive of you, doesn't mean it's an opportunity to get complacent. You want to document every step of your pregnancy or surrogacy or adoption journey, and you want to keep copies because we saw it with Kite Baby. Just because a company says, oh, we're owned by women for women, we're a families first company, we specifically serve pregnant people, that doesn't mean that they're not going to break the law.
Yeah. Or
Mhm.
even, put people over profits, which is something I try very hard to do in my own business. I
Mhm.
always am looking at, the people aspect. Again, it's that pull of you are running a business and you have to have money to run a business. And if you don't have money, then you don't have a business. And how do you
Yeah.
balance that with the humanity of I'm also running this business off of other humans and they are giving up their time with their families
Mhm.
and things that they love to help me chase this dream or build this business or serve these clients or reach this market or whatever it is. So, yeah, Kite Baby, it's super unfortunate. I hate that that happened. I do appreciate it as an onlooker because I learn from every single company that messes up out there and
Yeah.
missteps. I always learn something, and so I can appreciate it from that aspect as well.
Yeah, of course. No, lessons learned. And I know we've been here for a while. We did not talk about the Pump Act. So we can try to cover it now. We can maybe do another episode sometime. Up to you, HeHe. I want to respect your podcast.
Yeah, no, you as well. So maybe do you think we could cover the Pump Act in like 5 to 10 minutes and then we could wrap up?
Yeah, let me just give you the basic
Cool.
framework of the Pump Act. That is the Providing Urgent Maternal Protections for Working Americans Act, whatever that acronym is. They just wanted to make pump work, and that's what we
Yeah.
remember. The Pump Act protects you for up to 1 year after the child is born. So, in that 1 year, you're entitled to a private space free from intrusion that is not a bathroom to express milk. Okay. One of the problems we see is a lot of employers insist that you must use a bathroom and they'll make up all kinds of excuses. I've seen silly things like, oh, we're in the construction industry, so we're allowed to do a bathroom. There is no such exemption for the construction industry. Do not put it past your employer to make up rules that do not exist because they're just going to go to Google, aka I'mRight.com, and find the first blog that confirms their bias. And that's what they're going to do. Now, let's talk about the space itself. Not a bathroom. Cannot be a bathroom. I cannot emphasize that enough. They're going to try to put you in a bathroom. Not a bathroom. Can't do it. The Pump Act does not specifically require a refrigerator or running water in this space, although some states do. If you're in California, for example, there's a reason it's the front runner for workplace protections in the US. Refrigeration and running water is required. Now, the space, it does not have to be a dedicated pumping space. It does not have to be a space or a pod, although there are companies that make these and they're not particularly expensive. You can rent them, there's a lot of things you can do. They can have a multi-use area in the office that they just say, hey, when we have someone who has a need to express milk, this is that area, and it locks and it's private. Technically, a storage closet could meet this requirement. It's a pretty low bar, but the storage closet needs to be safe and reasonable. Look, I know it sounds gross and it can be. Not all storage closets are the same. Some are actually quite nice. But the point is, I had a discrimination case fairly recently where they put my client in a storage closet. And what they did to force her out is every day they put a little bit more junk in that closet. They put a few more chairs, a few more. And one day she went to go express milk in there because it was a private place free from intrusion. There was a mini fridge and a sink in there. So it met the California rule. She couldn't open the door. She thunk, couldn't, it was so stuffed full of stuff. And so in that case, we were able to show, like, yeah, you provided the space. That's what the losers at the defense firm are saying, like, oh, we provided the space. It's like, yeah, you provided the space and then you made it unusable by filling it full of stuff.
Again, it just goes back to like, why are you being a dick to a pregnant woman or like a
Yeah.
breastfeeding parent. Like, she's just literally trying to get
My
milk to feed
yeah,
her
look,
child.
I catch a lot of flack for being very openly partisan and biased because I am. I am a pro worker advocate. I say again, I
Totally.
said it once, I'll say it again. I am not a judge. If I ever become one, I will adjust the way I approach these cases. But as an advocate, it's my job to fight for the worker. What happened in this particular environment, it was so sad. This was an out of wedlock pregnancy, and the workers were very religious, and they had an issue with this pregnancy from day one. It was really gross. They had like a maternal approach to their employees. Like it was one of those places where the owners literally look at their employees as their children in like a twisted way. And they were upset that this was an out of wedlock, or what did they call it? They didn't say it was unholy. They said it was,
A sinful
I don't remember
conception.
what they call. Oh, I can't remember what they called it. It's gonna come to me. It's gonna come to me after we're done recording. But they had a name for it. I can't remember what it was. It'll come to me later. But they had a name for the pregnancy, and they were like discouraging her, but also like, "You're not going to get an abortion, right? You're not going to get an abortion." Like they just assumed that because it was out of wedlock, she was going to abort it. Like it was just the whole situation was just gross.
Well, it's also kind of like you're mean to me because I'm pregnant, but you tell me I can't get out of the situation. What the fuck do you want? Like, also butt out of my life.
You know what it is?
We're not going
It's
down that rabbit hole. We have to end here. We
No,
have to
I
end
deal
here.
with a lot of it. I deal with a lot of workplaces like that. You know, it's funny. California is seen as this big blue ocean, and it's really not. It's actually a few big blue bubbles surrounded by red. You go into the San Joaquin Valley, Fresno, San Bernardino, East County, San Diego. There's actually a very strong conservative presence in California, and a lot of people forget California was a very red state for a long time. Ronald Reagan was our governor before he became one of the most famous Republican presidents. So there is a very strong conservative undercurrent in California. It's not to say all conservative ideas are bad. I'm just saying that you will see a trend in the workplace where if we have owners who are very, very religious and think, hey, it's my company, my rules, I want to run this in a godly, religious way, they might impose some of the religious doctrine or religious morality onto their workers, and sometimes that imposition can be illegal.
Yeah, I struggle when people, let's say, make laws off of religion for a
Yeah.
whole nation of people that don't necessarily follow that religion or follow that
Yeah. Now,
stuff.
and I want to be clear too. I handle religious discrimination
Yeah.
cases. I don't do it anymore for a few reasons, but I actually had a few COVID when the
Mm,
vaccination rules were coming in. I had a group of people who through their church or religion, like, I cannot get this. My church
mhm,
literally says it's a sin. You're asking
mhm.
me to sin. And it's like, look, I don't touch the merits of a religion. If it's a sincerely held belief, it doesn't have to make sense to me. It doesn't even have to be really something I agree with. If it's a sincerely held belief, First Amendment, we're protecting your right
Totally.
to express your religion in this country. And to me, it's like, I feel like I'm protecting the Constitution and the American way more than anything else. So, all that to say, you have a right to live your religious ideology, but where the right ends is you can't impose it on others. Now there's reasons, there's reasonable exceptions. If you want to have an office Christmas party, I'm not suing you for that. That's ridiculous. Have an office Christmas party. That's fine. Merry Christmas, whatever.
Sure.
But when you start saying things like, "Oh, I will not hire unmarried women who are pregnant," like that's a
Mm,
problem. That's a big
yeah.
problem.
Yeah.
Yeah.
Well, yeah, I mean, yes.
Mhm.
We could, that alone could be a full conversation in
Yeah.
itself. Okay, Ryan, this has been super informative. I feel so much more educated on this topic, and I think I told you when we first kind of started was I didn't know a lot from this. I certainly didn't know about all of these acts and the
Mhm.
protections that we do have, albeit they are minimal and, compared to our other country friends, we are
Yeah.
really lagging. We're the caboose, but that's okay. We've got a lot of places that we can grow. And I'm glad that the conversation of the protection that we do have currently is getting out there and people are at
Yeah.
least going to know what they can ask for at work and where their rights lie after they have their baby and transitioning both in and out, kind of back to work.
I'm so glad. Thank you for inviting me to talk about this. There's some new laws and they kind of spiderweb out into a lot of different directions. I really really appreciate you asking detailed questions about these acts. And if people want to know more about these great resources, go to the EEOC.gov website. You can also go to the DOL.gov website. There are very helpful fact sheets. Now, I want to caution you, those fact sheets, they do not have the force of law behind them. They are just like this podcast. They're not legal advice. They are for education only. So if you read those fact sheets, you can't cite to them in court or anything, but they provide very helpful language in plain English about your rights.
Nice. Okay, and
Mhm.
you have amassed a huge following online because you give out such great information, and I think you really open people's eyes to things that we stay blind to and that we just are
Yeah,
not educated on.
thank
So
you.
tell people where they can find you on all of your social media platforms if they want your tidbits of information.
Absolutely. If you like information like this, you can find me at Attorney Ryan on TikTok and Instagram. You can also find me on Facebook as Attorney Ryan. I'm also on Threads at Attorney Ryan. And if you like long form content and podcasts where I go into much more detail about your rights and have very interesting guests and subjects, you can find me at Ryan Stygar on YouTube. We just crossed 150,000 subscribers. That community is growing. It's a very active community and it's a lot of fun. At Ryan Stygar on YouTube. And hey, if I offended you with my extreme political opinions today, follow me anyway and comment and tell me how angry you are. I appreciate the engagement.
Definitely comment. Tell us all of your thoughts, you guys. As usual, I will see you in the next episode. You can find me at Tranquility by HeHe on all social platforms or follow the Birth Lounge at the.birth.lounge on Instagram. See you next time. Bye, y'all. Thanks for joining us. I'll see you next time on the Birth Lounge podcast. Until then, head over to Instagram and find us at Tranquility by HeHe and give us a follow. You can also check us out at thebirthlounge.com.